So Sarah Boone has to now represent herself because she decided she was going to pop off at the mouth. She made that 58-page letter. I want to get into this order because he has had it. So the too long didn't read portion is this is her 58-page letter, um, forcing Judge Kraynick to read all of that. And he has to read every single thing. She wrote out from the Florida Constitution just straight legal definitions and things, just insulting everyone's intelligence, especially the judge, who she's supposed to be writing this letter to, even though it was a letter to us as well. And so it's so insulting, and he had to read every single page. So I know when he was writing this out, he said, I know I'm going to cook her. He decided to cook her up. But just in case you want to click off this soon, here's what happened in summation. Court minutes. The court addressed Attorney Cashman's motion to withdraw. The defendant was placed under oath. The court read on the record its order dated 6/28/2024 as it relates to the motion to withdraw to the defendant in open court. The defendant gave a statement and asked questions of the court of his order. The defendant was, I love that this was all caps. The defendant was provided a copy of court's order hand delivered on 6/28/2024 by Officer Jones and Thomas. When they say that the defendant gave a statement, I imagine that she fought back. I don't know if that's recorded, but that would be delicious to see. And so then his summary is the court made of the order. The court made findings that the defendant has forfeited her right to counsel. The motion to withdraw was granted. As a condition of Attorney Cashman's withdrawal, she shall provide the court an order for costs to obtain transcripts of depositions for the two witnesses she deposed. Upon completion of the transcript of the depositions transcripts shall be sent directly to the defendant at the Orange County Jail. Attorney Cashman shall file a notice with the court reflecting that the deposition transcripts were provided to the defendant. All previous set dates remain. All pretrial motions must be filed no later than close of business on Monday, July 22nd, 2024. The court ordered Attorney Cashman to provide the 2 boxes of discovery with the clerk marked as Identification A and B. The court will reach out to the jail to inquire how to deliver to the defendant. She has been complaining about this discovery for years. She has said, no one has let me be involved in my case. No one has let me do anything of my case. She said ad nauseum how she wants to be more involved than the world presently is. Well, now here is your chance. He said, you want to F around, you can find out. And here we are. So that's it in summary. Now I want to get to the actual order itself. It's only 16 pages in comparison to Boone's 58 pages, and it's typed so I can actually read it and not trying to read that scribbly scrap cursive, which she brags about her penmanship. I can't really read it well, but maybe it's good for some others. All right, order. This cause came before the court on June 28th, 2024 on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel, filed June 11th, 2024, the motion. The court having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, he is letting you know I did the research. So he is going to lay it all out, being like, this opinion did not come out of nowhere. I looked at everything. Having considered the positions offered by counsel Patricia A. Cashman, Esquire, having considered the testimony offered by the defendant, Sarah Boone, you better caps her name, and having considered the positions offered by counsel for state, hereby finds charges. A. On March 23rd, 2020, by way of information, the defendant was charged with second-degree murder. Procedural history. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, the Public Defender and Attorney Number 1, was appointed to represent defendant. C. On March 9th, 2020, the public defender moved to withdraw due to defendant retaining private counsel, Mauricio Padilla, Esquire, and the Padilla Law Group, Padilla and attorney number 2. Okay, so I didn't know that. So she says she's never fired anyone, but she did fire her first one because she got private counsel, and you can't get private counsel without getting rid of your public defender. I don't know a lot about Mauricio Padilla. I do remember hearing a rumor that he approached her thinking that, he can win. And maybe he did. He might have had a winning strategy. But after 2 years, right before, it was like a week or so, or weeks right before her trial, after 2 years, he pulls out due to irreconcilable differences. This is actually a timeline, so he's probably going to mention this. Let me just keep reading. On March 11th, 2020, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. E. On April 18th, 2022, 2 years later, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. I wonder why. As always, it is difficult to convey all particulars to the court and at the time maintain all duties to the client. This motion was served upon the defendant and defendant confirmed receipt. See later dated April 20th, 2022 and filed on April 26th, 2022. F, as in he had to get the F out of there. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing the defendant for 2 years. Period. I was right. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from defendant, a letter dated April 20th, 2022, and filed on April 26, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the court had received a letter from defendant, a letter on April 20th, 2022, and filed on April 26, 2022, which seemingly objected to Padilla's withdrawal. She said, please don't leave me. I do's better, I swear. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. Yup, he said, okay, bet, say less. Padilla requested an opportunity to amend the motion to address the irreconcilable differences. He said, you want receipts? I got them. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3rd, 2022 to prepare and file an amended motion with a hearing to be heard on the week of May 9th, 2022. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. The defendant testified to a lack of trust between herself and Padilla. That is just gold. When the court itself says, you really went in on your preparation here, and you did it in a timely manner, and I see what you're saying. And it must have been compelling because on May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented the original grounds. Ooh, what did he say? He supplemented, undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned's counsel ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him the opportunity to amend his previous filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. He literally said, if I gave you the details, it would be so bad that she could not have a fair trial. That's crazy. H. On May 6, 2020, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. The motion is in compliance with Florida rules regulating the Florida bar are present or whether the attorney-client relationship has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. See Sanborn 474, so day 2, whatever. On May 10th, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. She wanted him to lie, and he said, I can't. And she probably said, I want you to put me on the stand because she has a legal right to be going on the stand. And she's probably told him how she was going to lie in some way. And he can't, under ethical concerns or under ethical obligation, let her tell falsehoods or put her on the stand if he knows she's going to lie. That's just conjecture. That's just me putting that out there. But that's what I get when I read ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney, of course. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. They got this on attorney 2. This is when this was planted, that she is probably going to stall with attorney after attorney. And now we're on attorney number 8. And she did it, and she stalled out. She thought that she could just keep playing this game. And the court said he's done. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney and advised defendant about the dangers of self-representation. The court appointed the public defender, attorney number 3. That is so funny. On attorney number 2, they warned her about self-representation. And that's something that you need. She needs to understand and be put on warning that this could happen. And she's going to say that she wasn't. She's going to say that she had no idea, because in that 58-page letter, she even states, and representing myself is not an option. So she was advised up front this could happen. J. On June 6, 2022, the public defender moved to withdraw due to a conflict. On June 7th, that certain order allowing public defender withdrawal was entered, which withdrew the public defender from further representation of the defendant and appointed the Counsel of Criminal Conflict and Civil Regional Counsel, RCC, and attorney number 4. On June 10th, 2022, RCC moved to withdraw due to a conflict. Dang, she did not have luck. 3 days later, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdrawal was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consalo, attorney number 5. Now, here's the thing. Attorney number 3 and attorney number 4 was not her fault. It was they had a conflict. However, they had a conflict. One of them had a conflict because they were moving and just like leaving. So they said, I don't know why. I think it was an attorney number 3 was like, I don't know why they put me here because I am bouncing. Because she said in a past letter that he told her more than she ever knew, and it was such a shame that he left. And of course, she idolizes the one who left after giving her what she wanted, but whatever. And then the other one has a conflict because they represented George, because George was in the court a lot of times. And I think there's some cosmic irony here, because she mentions in her interrogation that she had him arrested 3 times. And she would do this a lot, and then she would get him bailed out the very next day. So I imagine, or in some instances, I imagine she may have been the cause for this conflict, because she calls the cops on him, gets him arrested. He needs a lawyer for whatever reason, because at one point she left him in there, so he did need to get a lawyer. And it could have been that lawyer. So she could have caused her own conflict with how she treated George. I don't know if that's true. It could have been he represented George for a completely different charge, but that is my headcanon, and prove me wrong. On July 8th, oh my gosh, July 8th, the Consalo moved to withdraw due to a conflict. So this is attorney number 5. What was this conflict? On July 11th, 2022, the certain withdrawal order was entered, which withdrew Consalo from further representation of the defendant and appointed Frank J. Bankowitz. Attorney number 6. So one, she had a public defense attorney. She got rid of them to have two. Two left because of irreconcilable differences. 3 had a conflict. I think 3 was the one who needed to move. Then 4 had a conflict, and 5 had a conflict. So I think those 2 attorneys were the ones that represented George, that they couldn't represent Sarah, and that's why they were granted that withdrawal so quickly. And then Bankowitz. So this is when Sarah's letters started to really get popular, was when she was bashing Frank Bankowitz with he wouldn't return her phone calls and he wasn't answering, and she gave him phone, or he gave her numbers that didn't work, and this and that he's a doofus or not good at his job, what have you. She insulted him so much. I think it actually affected his reputation because she was just slanderous, and he can't say anything back because, as attorney number 2 mentioned, you can't get into specifics without potentially causing prejudice in the future. So they could never even defend themselves from the onslaught of her attacks. And that's what she was trying to do yet again with number 8, Miss Cashman. And she did that with number 7, Hobson, but she only had a chance to write 1 letter for him. On July 12, 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted, which makes sense. Therefore, the court set a pretrial conference for October 25th, 2022 at 9 a.m. and the trial during the period beginning November 7th, 2022. Now, I don't think that was ever going to happen, but it's like, they just wrote it down just in case people were ready to go. On October 25th, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. On October 27th, 2022, what I love also about the labeling of this very specific timeline is that's what Sarah was doing in every single letter, trying to be petty. He did this for so many days. He didn't call me for so many days. We had a meeting that only lasted 12 minutes. She's been my lawyer for 100 days. Like, she would write out all of these times. So I love that she's getting a timeline right back that she can't argue with. On October 27th, 2022, Bankowitz filed defendant's motion to continue. On October 28th, 2022, the court entered that certain amended order on defense's stipulated motion to continue, which set a pretrial conference for January 17th, 2023 at 9 a.m. and trial during the trial period beginning January 30th, 2023. On November 22nd, 2022, the court set a status hearing on Tuesday, December 20th, 2022 at 10:45 a.m. On December 19th, 2022, Bankowitz moved to withdraw due to the irreconcilable differences which have arisen between the undersigned, his client, and his family. The undersigned will be unable to effectively and properly continue representing the defendant herein. Yes, because I forgot she brought in his family into these letters. So he said, I'm done. Nope, I can't be there. She's coming after me, my reputation, my family. Goodbye. On December 20th, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing on December 22nd, 2022 at 11 a.m. Oh my goodness, I knew he had an accident. I didn't know that it happened on that day, or maybe it didn't have to happen on that day, but happened that close. That's sad. And she was still mean to him. And in her letters, I remember she was like, I know you're recovering from a back issue, but that doesn't mean you still can't set up a phone call, that you can't answer my letters. Like, get the F out of here. You couldn't even have compassion for your lawyer who was recovering from an injury. Just so messy. W. On December 22nd, 2022, the reset status hearing was held. Bankowitz appeared virtually on, and due to technological issues, Bankowitz was unable to hear the court. Okay, that's sad. The court reset the status hearing for December 27th, 2022. X. Ooh, this is a big one. On December 27th, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant that the court had received a letter dated on October 3rd, 2022 and filed on October 7th, 2022, a letter dated November 3rd, 2022 and filed on November 3rd, 2022, and a letter on December 5th, 2022 and filed on December 14th, 2022. One letter in October, one letter in November, one letter in December, literally a letter on Bankowitz every single month. That is insanity. It's obsessive. The court conducted a Nelson hearing and defendant was not seeking to remove Bankowitz. I love how that was like bolded and italicized. I know he didn't. I know he probably has, clerks who write this for him, but I really in my mind imagine him late at night writing this, just cooking up a storm and reading her down. Was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages in discovery that he had reviewed and organized, and his contact and potential use of in collaboration with expert witnesses, including experts that Padilla, attorney number 2, utilized. Bankowitz advised the court of defendants' attempts to call Bankowitz at a rate of 5 to 10 times a day. Wow. No, 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 no. My mama can't even call me 5 to 10 times a day. Not picking up. Absolutely not. That's absurd. And she did that only to aggravate him and to needle him into responding. And every time I see these antics, I keep thinking, she knows these are being monitored, documented, that anyone could see this at any time. And this is how she behaves. Imagine how she behaved in that relationship. What can you believe from her side of the story that she keeps saying she wants to give? If this is how she behaves when she knows she's being watched, how did she behave when she didn't know she was being watched? We kind of got an instant because she filmed it, and I guess she didn't think anyone would ever see it. I personally do have a theory that she deleted that video very early on while she was still drunk. And so she genuinely does not remember it, but also did not think that the police would ever find it. And then she's so like frozen statue shocked when she sees it in the interrogation, because I think it's all slowly coming back to her and hitting her at that moment. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, defendant reposited that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication. She did do that. That was so rude. She put in that he had other issues with other clients that were completely unrelated to this, but she just put that in there to be mean and to try to embarrass him and to try to weaponize that against him. Alleged Bankowitz's actions in the case rose to a similar level and then sought to remove Bankowitz herself, basically trying to beat him to the punch. The court pointed out defendants' inconsistent statements within minutes of them being made and addresses concerns over defendants' motivations, especially when there is something defendant disagreed with. Dang, saying she was caught contradicting herself in open court and confronted with it. And she did that in this last hearing too, because she said that Patricia Cashman, Esquire, lied, and Judge Kraynick cut in and said, "Tell me the lies." And she's like, "She lied to me about getting a bond. She said my brother would have to come down here and take pictures and provide evidence and this and that." And he's like, "Okay, that's truthful. Where's the lie?" everything you just said, that is what happens. Where's the lie? And then she goes, well, Your Honor, how am I supposed to know this if no one's telling me because I don't have this? So it's like she keeps saying she's so intelligent in her observations about everything. But when she doesn't know something, it's, well, how am I supposed to know if no one's talking to me? No one's answering any of my questions about anything. How come I can't see my discovery? How come I'm not included in my case whatsoever? My attorney doesn't give me what I ask, this and that. Well, now your prayers have been answered. You will get every last file of your discovery dropped off at whatever cell door you at. I don't know how you actually store that, but good luck. Um, and it will be all yours. No one will hold back anything from you. You will have absolutely everything your lawyers had. The court specifically advised defendant that she is not entitled to endless line of court-appointed lawyers until you find the one that you personally prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17th, 2023. He said, work it out, withdraw. I forgot about this. He had to try to withdraw twice. And so, yeah, again, this is another time she is being warned. You could represent yourself. And in that 58-page letter, she said, I am not representing myself, even though my last judge and this judge have threatened me with it. And she wrote it in such a condescending way, as if they wouldn't actually do it. She is learning. She is learning quite quick. Why? Oh my gosh, there are so many letters. There's a double A. Jesus. Okay. Why? The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to same. Basically, these experts saw the case and they heard about her, and they were not willing to testify for the rate that JSC was going to offer them. Which I get it. If they're like, you're going to try to put me in this high profile case and talk for her, like give her something that'll help her, where everyone's going to see me, and you're going to pay me that much? Nah, pass. Good luck though. Z. During this time period, the court had received several letters from the defendant. A letter dated January 10th, 2023, filed January 17th, 2023. Later dated March 22nd, 2023, and filed on April 14th, 2023. Those two letters were filed together. A letter dated May 15th, 2023, and filed on May 18th, 2023. A letter dated June 29th, 2023, and filed on July 21st, 2023, and a letter dated August 2nd, 2023, and filed August 7th, 2023. Jesus Christ. January, March, April, May, June, August. She didn't write one in July. It was filed in July. She gave the girls a break in July. And then August. She is writing these letters to the judges every single month. And the thing is, she's not actually putting motions in there. The judges read the letters, seeing, what are you asking me to do? You are complaining, but you are not asking me in a legal capacity to do something. This is not a motion you're filing. You are not bringing up actual legal issues. You are complaining that they are not doing what you want, and that they're inferior, and that you're smarter than everyone, and that everyone should do what you said. They can't do anything with those. And she doesn't get that every one of those letters will be used against her when it comes to sentencing, because they all speak to her character. Is there rehabilitation for Sarah Boone? I don't know. For years, not 4 years, 5 years, but for years, she has acted the exact same way, with zero improvement, zero self-awareness, zero change in her behavior. She treats every single lawyer the same. She said on the day one, she told Miss Cashman, Esquire, that your snotty attitude is not appreciated. Who are you to start day one like that? when this was your 8th attorney. That tells you everything you need to know about that type of person. So I do not feel bad for her at all. She will struggle on this stand. It will be embarrassing, but she more than worked this upon herself. Note 7, the January 10th, 2023 letter sets forth ad hominem attacks on Bankowitz's professionalism and morals. Yup. Number 8, on June 15th, 2023, the May 15th, 2023 letter sets forth ad hominem attacks on the court, alleging that Judge Wayne C. Wooten was being monetarily compensated from third parties' use of information that is publicly available. Oh, he cooked on this one. I am so glad that he is saying everything that we have been thinking. And I just didn't actually think they would say that out loud. I'm so glad they are. She did. She said, and she even said in this last letter that everyone is profiting off of her case. She said the judge was taking kickbacks and like, what's your cut in this? She was saying that to be snotty and whatever, but she doesn't realize those are legal allegations with huge consequences. They have to take those seriously. So yeah, they're going to remember that you said that. 9. The June 29th, 2023 letter sets forth ad hominem attacks on Padilla, which were not raised during either the April 29th, 2022 hearing or during the May 10th, 2022 hearing on Padilla's motions to withdraw as set forth above. So she just took that letter to just be mean on to her second attorney for no reason. I guess she was bored bullying Bankowitz and decided to circle back. Double A, on August 22nd, 2023, Bankowitz again moved to withdraw. 1. Irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client. Meaning he can't really just say all the horrible things that he wish he could reveal. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Miss Boone's case. Yes, because I believe that he was also dealing with a death penalty case, and he let her know that death penalty cases take way more time and stress. And she said, well, I'm a murder case too. And it's like, okay, you can't have any compassion for the stress this man must be under dealing with that level of case. Yes, you are going to go to jail for the rest of your life. Yes, that is, a death sentence in itself. However, wait your turn and let him focus at one client at a time. But you can't, because it's all about you. The best possible avenue is to have the defendant represent herself as no attorney can satisfy her. Attorney number 6 said this. So did 7, so did 8. BB. On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, i.e. dud, buffoon, and berating behavior. The court advised defendant that the court had received letters from defendant, a letter dated August 26, 2023, filed on September 7th, 2023, and dated August 30th, 2023, and filed on September 2nd, 2023. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson, and attorney number 7. Thereafter, the court set a status conference for October 30th, 2022 at 10 a.m. and set pretrial conference for November 28th, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that, quote, if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. Meaning, if you keep this up, I'm actually going to take these letters. Like right now, he's taking these as a joke and ignoring them. He's like, I'm going to actually look into them and respond the way I need to respond. Hint, hint, just like this judge has responded. So this is what she was working up to this whole time. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e., go to trial and or to testify. Yeah, those are the main ones. The court cautioned as the defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. The court said, if you're broke, just say so. Otherwise, hire your own counsel. That way you can have them do whatever you want. But as long as you are still broke and you're on my dime, you need to reel in your expectations. CC, goodness. He says CC the whole world on this email of a court order. I love it. I'm loving this. I don't know about y'all. On October 30th, 2023, the status conference was held. Hobson advised as to his conversation with defendant and setting on status in January 2024. Thereafter, the court set a pretrial conference status as to readiness for trial on January 16th, 2024 at 9 a.m. and trial during the trial period beginning January 29th, 2024. DD. On January 12th, 2024, Hobson filed that certain motion to continue, waiver of presence, and requested a 3-docket continuance. EE. On January 16th, 2024, the court addressed Hobson's motion to continue, granted saying, set a pretrial conference for May 3rd, 2024 at 9 a.m. and during the trial period beginning May 13th, 2024. FF. On February 1st, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. Ethical considerations, I'm taking that to mean that she's asking him to lie again, and to do something he legally can't. On February 9th, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, probably the ethical concerns, on what can and cannot be done, probably her trying to lie, a lack of resources. You don't have any money, so you can't complain about the experts that I can or cannot give. And defendant's demands make her difficult to work with. I believe that, including defendant taking non-viable legal positions and being unreasonable. Yeah, so she probably has like a jailhouse lawyer friend who's in there and just feeding her all of these power lines and big words to say that don't actually apply to her case. So she goes in there and is like, habeas corpus, mens rea, compus mentis. And he's like, man, this is a Wendy's. Can you please sit down and we go over these files? As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what defendant has in mind. See, the expert doesn't even want to do what she wants to do, and now she's complaining about that. The court advised defendant that the court had received a letter from defendant, a letter dated January 19th, 2024, because of course she had to complain about him. The court outlined the overriding claims for withdrawal by Padilla, Bankowitz, and Hobson, basically being like all three of these lawyers withdrew because of adversarial relationships, lack of satisfaction, and inability to meet defendant's desires. Basically, she was impossible to work with. Yet in her letter, she says, just like the prior attorneys, they always blame their deficiencies on or dysfunctions on me. I'm like, one time, sure, twice, maybe, 8 times, it's on you, girl. The court found that all of defendant's relationships with all court-appointed counsel have deteriorated such that defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed lawyer, and that defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. He had to make sure he bolded twice, may not, and if circumstances similar to Hobson's motion to withdraw occur. Kind of like with what's happening with Miss Cashman, Esquire. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Basically being like, remember Darrell Brooks? You want to turn out like that? It's going to be hard. And that's why they keep saying that. They're calling it dangers and warnings because they're like, once that door is open, you are on your own. And you will have to struggle through this whole case because of your actions. And every time we are warning you, we are telling you these things. And you go letter after letter after letter saying the exact same thing about every single attorney, thinking you're untouchable, thinking you know all. Well, if you know all, let's see how you do. You will be an excellent attorney. You will be perfect because you are so, quote, intelligent in all of your observations. All of these other lawyers ungracefully bowed out, as you say. But you can stand up for yourself. You can take up your own sword of justice. Martyr yourself. Show me all the evidence. Show the world that we are all wrong about the video you filmed on your phone of you killing your boyfriend. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, and attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. Someone who is known for dealing with difficult clients. And that's why she said in her responses, she's like, she keeps telling me she's putting this to rest. I'm not having this conversation with you. And I'm like, that is the mark of a true diva who knows her time, her worth, and what needs to get done. I'm putting this to rest. I'm using that in my everyday life. The court set a status hearing for April 12, 2024. On April 12, 2024, the status hearing was held. Cashman advised as to the depositions that had been set, the hiring of an expert, and a request for future status date to address a trial date. The court set status hearing for June 7th, 2024, basically asking for more time. On June 7th, 2024, the status hearing was held. Cashman addressed her dates of availability. Defendant was present for the hearing and was sworn. Thereafter, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman, utilizing a pretend judge to oversee defendant and Cashman. I know that probably made him hot to read, just being like, are you kidding me? You're using pretend judge? Because he made sure to pull that out. Utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th, 2024 and June 7th, 2024, and both of which were filed on June 21st, 2024. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman addressed disagreements on legal strategy, including defendant attaching importance to issues that may not be legally. In riposte, defendant accused Cashman of lies and half-truths. JJ, on June 11th, 2024, Cashman moved to withdraw under Florida rule regulating the Florida Bar 4-1.7b2, substantial risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, and irreconcilable differences, including but not limited to ethical considerations, have arisen such that counsel can no longer provide representation. And Sarah has said many times in the past, disagreeing on legal strategy, saying, there's more than one way to win. There's more than one way to win. No, there isn't. You have 0 ways to win. There is no ways for you to win. There were maybe a plea deal where you could have not gotten life in prison, but that's it. You are not winning this case in any way. And now the judge is not letting you back down. KK, on June 28th, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating Florida Bar and Schwab v. State as the basis for the withdrawal. LL, at no time has defendant refused to accept the services of any of her 7 appointed attorneys. The law. So now he's bringing in the law to back up his decision. Both the United States and the Florida Constitutions guarantee an indigent, broke, criminal defendant the right to assistance of appointed counsel. See U.S. Constitution Amendment 4th, Article 1st, Section 16, Florida Constitution, Boone v. State, whatever. NN. The counsel clause of the Florida Constitution under Article 1, Section 16 recognizes the right to counsel as well as self-represented in all criminal prosecutions. So this is saying what the law is. So yes, you do have a right to appointed counsel. And now he is saying forfeiture of right to counsel. OO for oop. A defendant in a criminal case can forfeit a right to court-appointed counsel. PP. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. KR v. Department of Children and Families, citing Commonwealth v. Means. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. Basically, you're abusing all of this stuff, and she has been going through 8 attorneys. This is the textbook definition of abuse of the attorney system. As set forth above, defendants' recalcitrance to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. RR. It has become apparent to the court that defendant will not permit herself to be represented by anyone. See US v. Travers. SS. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that defendant had forfeited his right to counsel. See Watson v. State, receded from another grounds by Waller v. State. Okay, a 1995 case. After the withdrawal of 6 different court-appointed attorneys, the trial court determined that Watson had forfeited his right to counsel and then proceeded to trial with Watson representing himself. Following the jury's verdict, the trial court immediately sentenced Watson. We conclude that the trial court did not err by determining that Watson had forfeited his right to counsel. However, it does not necessarily follow that he forfeited his right to have counsel for the sentencing phase, which is a critical stage. Okay. So even though she might flounder in the trial, she could still have counsel when she's being sentenced. PT, under Florida law, the facts at bar amount to a binding forfeiture to the right of counsel. See Jackson v. State. I do want to see this. What are these binding whatevers? Okay, so I guess this was appealing this guy representing himself. None of the points raised on this appeal for a conviction for aggravated battery with a machete, Jesus, after a jury trial presents reversible error, discussing the most significant ones, which each stem from the indigent defendant's self-representation at trial. So they're saying every point that he brought up on this appeal was because he had to represent himself, which is what Sarah is going to do once she is sentenced. And so I'm guessing they're using this as a framework. The trial court did not err in requiring Jackson to proceed without counsel. This is because his recalcitrance, antagonism, and even personal attacks, so he took that exact language from this case, each of a lengthy series of court-appointed attorneys, all of whom were required to withdraw, rendered it obvious that he simply would not permit himself to be represented by anyone and amounted to a binding forfeiture or waiver of that right. Period. Yeah, people don't get your rights can be taken away. And then in the second one, the appellant characterizes as self-initiated interjections by the trial judge were motivated by the judge's appropriate interest in preserving the regularity and orderliness of the proceeding. So this person was probably like, the judge is against me. More importantly, they were not skewed against the defendant and thus did not deprive him of a fair trial so as to require a new one. And then 3, an erroneous comment by the prosecutor as the burden of proof was not objected to and was not fundamental error. Okay, so I guess he was like, this prosecutor said this thing that was terrible, but you didn't object to it. So there was no error. Because like the appeals courts aren't there to rejudge the case. They are only there to judge the judge. Did the judge make all the right calls during the case? If they did, then the appeal is not granted. That's why appeals are very, very rare. So legally, if she did not object, the judge did nothing wrong by not sustaining an objection that was never made. Cool. Now, what are these footnotes? U.S. v. Thomas, which found the misconduct of relationships with 4 attorneys, including verbal abuse, tearing up correspondence, refusal to cooperate in producing a witness list, hanging up on counsel during a telephone conversation resulted in forfeiture of the right to counsel. She admitted to walking out twice on her, being like, I'm not going to waste my time. She's not going to waste my time if she's going to do da-da-da-da-da. So there you go. Verbal abuse, maybe not tearing up correspondences, but hanging up on counsel for sure. And then citing U.S. v. Irene, forfeiture of a right to counsel can be found through a pattern of serious misconduct, abuse, threats, and utter failure to collaborate with his own defense. Repeated abusive, threatening, and coercive behavior toward counsel can result in the forfeiture of the right to counsel. Coercive behavior, let me add, pretend judge. You need to treat me as though a judge is in front of me. You need to treat me like this. Yeah, this judge laid it all out. He did his research and said, you're not getting out of this one. As the court finds, defendant has forfeited the right to court-appointed counsel under Florida law. There is no obligation to conduct a FORFEITS hearing or to otherwise warn a defendant of the dangers of proceeding pro se. I'm guessing FORFEITS hearing means this is what being pro se means. Okay, a FORFEITS hearing is like, are you allowed to represent yourself? He's saying we don't even have one of those meetings. You will be representing yourself. Or to otherwise warn defendant of the dangers of the proceedings because she has been warned so many times. Waiver by conduct. VV. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. WW. On February 9th, 2024, defendant was twice advised that another court-appointed attorney may not be provided. She thought they were playing jokes. She thought they were still playing this game, and she didn't take any of that seriously. Bet you she will now. XX. On May 10th, 2022, defendant was advised about the dangers of self-representation. YY. On February 9th, 2024, defendant was advised about the dangers of self-representation. ZZ. As of February 9th, 2024, the instant case had been continued 16 times. This case has been continued 16 times. Good Lord. AAA. As on June 26, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing of the information on March 23rd, 2020. Bolded, underlined. I also think this is a gag because in all of Sarah's letters, 100 days, it's been 300 days. She used to like to write out the very specific to the day. And I love that he just threw that back in her face. Triple B, actions speak louder than words, period. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to defendant's attention on May 10th, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, fail to meet and communicate, and when defendant is provided court-appointed counsel who will meet and communicate, Cashman, Esquire, the ways and means of meeting and communicating are not acceptable to the defendant. Triple C. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel, and that's the one we reviewed earlier. Oof. He laid it out from A to triple C, A to Z, double A to double Z, triple A to triple C. Orders and adjudges as follows. I also like that she put, unless adjudged otherwise. I'm innocent unless adjudged otherwise in her letter so many times. So, orders and adjudges as follows. Cashman's motion to withdraw as counsel filed on June 11th, 2024 is granted. 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts. Okay, this is what I read at the beginning. Defendant Sarah Boone by Cashman. Okay, basically give Sarah all your shit. 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. 4. Alternatively, defendant Sarah Boone, as through waived by her conduct, her right to court-appointed counsel. She acted the way she acted, and now she can act that way alone. 5. The trial management conference shall remain specially set for Tuesday, September 24th, 2022 at 1:30 p.m. 6. The case shall remain specifically set for trial for the 2-week trial period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. He says, even if you get a lawyer, I'm not pushing this back. If you get a lawyer, they need to catch up to everything in a few months, because you're going to trial. 7. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd, 2024. Does she even know what a pretrial motion is? I doubt it. Done and ordered in chambers at Orlando, Orange County, Florida, this 28th day of June 2024. E-signed by Michael Kraynick. You better go off. Honestly, I think this is good. It sets a good lesson for other people because you've had Daryl Brooks, now you have Sarah Boone, who think that they can do all of these stalling tactics. So it's good to actually hold someone accountable and say, keep playing these games and the games will play you. Alrighty, until next time, like, comment, subscribe, or dislike, whatever you're feeling.